After months, sometimes years, of watching your priority date sit frozen, July 2026 just moved the needle for thousands of family and employment-based green card applicants, and a federal judge just handed thousands more a temporary win on their work permits. But here's the catch: one wrong chart, one wrong assumption, and you could file too early or miss your actual window entirely. In this video, I'm breaking down every category that advanced this month, which chart you're actually supposed to use, what the court order does and doesn't protect, and exactly what you need to verify before you file anything. After months or even years of waiting, July 2026 has finally brought some encouraging movement for thousands of immigrants waiting for green cards, immigrant visas, employment-based cases, family petitions, and permission to work in the United States. In this video, we are going to talk about the positive July 2026 movement for family-based and employment-based green cards, which priority dates have advanced, how the USCIS filing chart could allow some applicants to take the next step, what the latest court ruling means for certain work permit holders, and what you should check immediately to determine whether any of these developments benefit your case. Now, let's get into the video. The first major positive development comes from the July 2026 Visa Bulletin. Every month, the Department of State publishes cutoff dates for family-sponsored and employment-based immigrant visas. These dates are crucial for applicants. July shows movement in several family-sponsored final action dates. In the F1 category, unmarried adult sons and daughters of U.S. citizens, the final action date moved from September 1st, 2017 to February 1st, 2018 for most countries, including China and India, Mexico, and the Philippines. Dates remain unchanged, highlighting uneven Visa Bulletin movement. In F2A, spouses and children under 21 of permanent residence, the main dates did not move. For most countries, the date stays January 1st, 2025. For Mexico, it's January 1st, 2024. However, the dates for filing chart for F2A remains current, allowing applicants to file Form Y-485 in July, despite final action date limitations. This distinction is critical. Current dates for filing can enable application submission, but final approval depends on priority date alignment with final action dates. Filing Form I-485 can also permit employment authorization and advanced parole while applications are pending. Applicants must remember that being in the U.S. doesn't guarantee status adjustment. They must qualify under immigration law closely. The F2B category for unmarried sons and daughters over 21 also sees movement. The final action date for most countries moved from September 22, 2017 to November 22, 2017. The Philippines advanced from April 8, 2013 to May 15, 2013, while Mexico remained unchanged. The dates for filing chart advanced for most F2B applicants, allowing eligible individuals to apply based on the new cutoff and other requirements. The F3 category, married sons and daughters of U.S. citizens, moved forward. Most countries saw the final action date move from February 15, 2012 to April 15, 2012. Mexico moved from May 1, 2001 to June 1, 2001, and the Philippines advanced from November 22, 2005 to February 22, 2006. These changes signify improved action for a larger group of applicants. In the F4 category, brothers and sisters of adult U.S. citizens, the final action date for most countries advanced from November 8, 2008 to January 1, 2009. The Philippines moved from July 15, 2007 to August 1, 2007, while India and Mexico saw no movement. The F4 dates for filing chart also advanced, aiding families waiting for years. A priority date must generally be earlier than the cutoff date to be considered current. There's significant employment-based movement in July. In the EB1 category for priority workers, China's final action date advanced from April 1st, 2023 to June 1st. India's EB1 date moved from December 15th, 2022 to October 15th, 2022, a 10-month advancement. EB1 remains current for most countries, including Mexico and the Philippines, allowing unrestricted visa availability for qualified applicants. The employment-based second preference, or EB2, remains current for most countries other than China and India. China remains at September 1st, 2021. Unfortunately, India EB2 is unavailable for the remainder of fiscal year 2026 because the available numbers under India's annual limit have already been used. Unavailable is different from a date remaining unchanged. It means no additional immigrant visas can be issued in that category during the remaining fiscal year, even for someone whose priority date had previously become current. The Department of State has indicated that issuance may resume after the annual limits reset on October 1, 2026. It has also said that the date could advance at least to the date announced in the May Visa Bulletin, but the exact October position will depend on demand and the fiscal year 2027 visa allocation. Indian EB2 applicants should therefore not interpret the broader July good news as an immediate reopening of their category. They should continue preparing their cases and monitoring future bulletins, but final approval must wait for visa numbers to become available again. The EB3 category offers broader positive movement. For most countries, including Mexico, the final action date moved from June 1st, 2024 to August 1st, 2024. China EB3 advanced from August 1st, 2021 to December 22nd, 2021. India moved from December 15th, 2013 to January 1st, 2014. The Philippines remained at August 1st, 2023. The other workers category also advanced for several countries. For most countries and Mexico, the date moved from February 1st, 2022 to March 1st, 2022. India moved from December 15th, 2013 to January 1st, 2014. And the Philippines moved from November 1st, 2021 to December 1st, 2021. China remained unchanged at April 1st, 2019. EB4 and the certain religious workers category received 2 months of advancement across the published country columns. Their final action dates moved from July 15, 2022 to September 15, 2022. There is mixed news in the unreserved EB5 investor category. China advanced from September 22, 2016 to December 1, 2016. But unreserved EB5 for India is unavailable for the remainder of fiscal year 2026 because the applicable annual limit has been reached. The EB5 set aside categories for rural projects, high unemployment areas, and infrastructure projects remain current for all listed countries. Applicants should remember that eligibility for a set-aside category depends on the qualifying investment and petition. A person cannot simply transfer an unreserved priority date into a reserved category without satisfying the applicable legal requirements. These changes show that July contains real movement, but it is not a single government order accelerating every green card case. It is the result of visa number availability, demand, annual country limits, category limits, and the government's effort to use the available immigrant visas before the fiscal year ends. The Department of State has also warned that additional demand could lead to retrogression later. A category can move forward and then move backward if more eligible applicants appear than the government expected. That is why someone who becomes eligible to file should not automatically assume the opportunity will remain available indefinitely. Before I walk you through the exact steps to verify whether you can actually take advantage of this movement, if you're finding this useful, go ahead and subscribe so you catch these breakdowns as soon as they drop. If your priority date is earlier than the applicable cutoff and USCIS permits your chart to be used, you should determine whether you are eligible to take the next step. But you must verify the category, country of chargeability, priority date, and filing chart before submitting anything. Family-sponsored adjustment applicants may use the dates for filing chart in July. Employment-based applicants must use the final action dates chart for July. Using the wrong chart is one of the most dangerous mistakes an applicant can make. The Department of State publishes both charts, but USCIS separately decides which one adjustment applicants may use in a particular month. Applicants should also understand the difference between country of citizenship and country of chargeability. Chargeability is commonly based on the applicant's country of birth, although limited exceptions and cross-chargeability rules may apply. An applicant born in India who later becomes a citizen of Canada does not automatically use the General Canada column. Likewise, a person should not select a more favorable country merely because the person currently lives there. The principal applicant's spouse may sometimes create a cross-chargeability opportunity if the spouses were born in different countries, but this is a legal determination that should be evaluated carefully. If you believe your priority date is now eligible, review your I-30 or I-40 approval notice and confirm the priority date printed on it. Then, compare that date with the correct July chart. If the case is proceeding through the National Visa Center, monitor the CAC account and NVC messages. Make sure the required fees, civil documents, Form DS-260, police certificates, and affidavit of support materials are complete. Becoming eligible under the dates for filing chart does not guarantee that the NVC will immediately schedule an interview. Interview timing also depends on documentary qualification, consular capacity, security screening, and the availability of a visa number under the final action dates chart. If the applicant is eligible to adjust status in the United States, make sure the correct Form I-485 edition is used and that all required signatures, evidence, medical documentation, and filing fees are included. July also brought separate good news for certain immigrants facing the possible loss of employment authorization. On July 21st, a federal judge temporarily blocked the Trump administration from enforcing policies that could have stripped tens of thousands of asylum applicants and TPS holders of their ability to work. The dispute concerns immigration fees and employment restrictions from a 2025 law. The legal challenge argues these policies shorten employment authorization for TPS holders from El Salvador, Sudan, and Ukraine, harming affected immigrants. The court did not eliminate the fees. With a temporary order in place, the government can't revoke work permits over unpaid fees or impose penalties. This relief is temporary. A judge may extend this pause, and the case could continue through litigation. Applicants shouldn't assume expired employment documents are automatically extended. TPS and employment authorization validity involve different dates and requirements. Those on TPS or pending asylum should verify their employment card category, expiration date, country notice, and any USCIS or court updates. Keep copies of receipt notices and employment documents. If an employer questions authorization, provide acceptable documentation under the Form Y-9 process. Avoid creating or altering documents not supported by the court order. The positive message for July isn't that the immigration system has sped up. Rather, several family and employment priority dates have advanced. Many family-sponsored applicants have broader filing opportunities, and a federal court has temporarily protected work authorization for many affected immigrants. For eligible priority dates, July could allow submission of documents, adjustment applications, final actions, or immigrant visa interviews. Each applicant must check their specific category. A date moving in F3 won't help F4. EB3 movement doesn't reopen India EB2. A current filing date doesn't guarantee quick approval. A temporary court order doesn't grant permanent work authorization for all asylum or TPS applicants. Review official notices instead of depending on social media headlines. Confirm your priority date, category, country of chargeability, USCIS filing chart, NVC status, and work permit expiration. If your date is eligible, prepare carefully. If backlogged, don't submit a premature application just because another category has moved forward. July 2026 has brought genuine progress for some immigrants. While it won't erase backlogs, forward movement is an opportunity for families and workers awaiting change. That's all we have for this bulletin. This bulletin provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2 work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, EB5, and family immigrant visas. Follow for more updates like this one, and subscribe to the channel so you don't miss what's coming next.